Someone make it make sense.
Probably a couple.
Howdy, howdy, Scroll friends. We are here with the first Bryan Kohberger hearing in Ada County. We're going to meet our new judge, and let's see what he's got to say.
All rise. District Court is now in session. Honorable Judge Hippler presiding.
Here he comes. Here he comes.
Be seated.
Very different, like first impressions, like very different from what we're used to with in Ada County, or sorry, Latah County. This looks very high definition, if as it were. Like the color is more saturated, like I guess better cameras. Hopefully the microphones are better and not recorded on a potato. So
All right. Good afternoon. This is State v. Kohberger. I want to go over the appearances this afternoon on behalf of the state. Would state attorneys please represent themselves for the record?
Thank you, Your Honor. My name is Bill Thompson. I'm the Latah County prosecutor. This is Ashley Jennings. She's my senior deputy. And then we have Mr. Nye and Ms. Beatty from the Attorney General's office. And then we have victim support staff with us.
it's Bill
Right,
Thompson.
thank you. Defense?
Ann Taylor, attorney for Bryan Kohberger, Elisa Massa, and Jay Logston, counsel for Mr. Kohberger as well.
Thank you. All right. Like to tell you I'm happy to be here, but why start with an untruth? I am
Wow. Hold on. Did you guys hear that? Hold on. What?
Thank you. All right. Like to tell you I'm happy to be here, but why start with an untruth? I am accepting of my responsibility to be here.
Wow.
I want to go over with you some.
That is insane. That's, wow, what a way to start this of like, wow. I mean, so I guess I expected him to say after he said, like, I'd like to tell you I'm happy to be here. I kind of expected him to say something like, but, this is a tragic case, horrible murders. It's unfortunate that people died, something like that. But instead he says, like, I'm accepting of my assignment, which makes it sound like, do you not want to be a judge, sir? Like, why are you, like, this is your job? I mean, I guarantee you these attorneys are happy to be there. And what I mean by that, again, is because this is their job and they love their job, hopefully, right? I mean, you definitely get that feeling from Ann Taylor and the defense team, 100%. There's a lot of passion and for their job. I just, what is that even supposed to mean, right? Like, what is that supposed to mean? Hold on, let's listen again. This is very, very pessimistic, very, like, what?
All right. Like to tell you I'm happy to be here, but why start with an untruth? I am accepting of my responsibility to be here. I want to go over with you.
I mean, if he's just going to say something like that, he may as well not say anything at all, right? You don't have to say you're happy to be there. If you're not happy to be there, you could just not say anything. You could just say, I'm the judge assigned to this case, and then go forward from there. I don't know. What do you guys think? That's really, like, it's like saying something. Like, what does he mean? Is he like, I don't want to work with, like, is that supposed to mean like he doesn't want to work with these attorneys? Is it supposed to mean that he just doesn't want to be a judge in general? And why would you want to give everyone in the room that impression? Like, why do you want them to know that you, like, hate them, essentially? I don't know. Weird.
Some expectations of mine given that I don't think any of you, other than Ms. Massoth, have appeared in front of me before. When you file
Does he
memorandums,
does he say this to every case? Does he say this to every defendant, to every group? Like, does he always say this? Is he always like, yeah, I don't want to be here? Weird.
law, briefs, et cetera, please provide a Word copy by email to my staff attorney. After today's hearing, you may get that from staff here today. Today, I know there was an issue that was brought up with respect to Mr. Kohberger's attire for today. I did issue an order yesterday permitting him to appear in civilian clothes for this hearing only. That is a matter in terms of future hearings that we will take up in a closed hearing the day of, but in advance of whatever our next hearing date will be. My intention will be that Mr. Kohberger will not be present for that hearing because part of what we will be discussing are security measures. And I expect to hear from the transport deputies and the bailiffs regarding security issues that they want to address or that I have questions for them about so that I can make an appropriate ruling in terms of his appearance here, but weighing that not just against, of course, his rights, but also against the needs of security in this case.
That's interesting. So we don't know yet then if he's going to be allowed to wear his normal clothes. And I will say though, as far as the security goes, we know that like with Chad Daybell, for example, which was in the same courtroom even, different judge, but same courtroom, he was able to wear his street clothes. And that was, also a high security death penalty case. So I would imagine that they should be able to figure that out.
I do expect, as it probably will come to no surprise to you, for you all to get along. I understand the stakes in this case are as high as they can possibly be in any case, but you are professionals. You have taken oaths, both as of officers within your jurisdictions, but also as attorneys before this bar. So I expect at all times for you to remain civil to one another, that you not engage in personal attacks, ad hominem attacks, that you not engage in theatrics, not misstate the facts or the law to the court, and that when you cite arguments in your—
Let me pause right there. This is another one that's interesting. I don't know if he's maybe not watched prior hearings. I mean, probably not. But I would say, this is my personal opinion, I would say these attorneys have been very civil and mild-mannered, and there's not been theatrics. There's not been ad hominem attacks. There's not been any of that like you see sometimes in other trials. They've been very civil and polite. I would say the spiciest moment that I can recall was between Bill Thompson and Dr. Edelman, who was a witness for the defense. But even that, I would say, wouldn't have risen to the level of anything he just mentioned. So I don't know why he's scolding them when they haven't done anything wrong. So far, it's like if I was one of these attorneys, or it's even a legal assistant, it's like you're hearing, okay, the judge doesn't want to be here. He automatically doesn't like us, and he's like scolding us for things we haven't done. I don't know. What do you guys think? It's interesting.
your briefs, if there is contradictory precedent, I expect to see that.
Now that's standard. That's general best.
I appreciate in advance what should go without saying that I've just said in terms of your responsibilities. But again, I just want to highlight that because I understand when the stakes are high, sometimes victory seems to be the objective when our first objective is to
Justice?
conform to the oaths that we've taken as members of the bar, as officers of this court. All right. I do have some matters with respect to scheduling that I want to go over today, but before I do that, I'd like to hear from you with respect to the matters that you either need to make me aware of or want to make me aware of. The other thing before I do that, though, I do know that Judge had entered a non-dissemination order. That still remains in place. And unless I, for some reason, remove that order, it will stay in place, and I expect it to be religiously adhered to by all parties, counsel, victims, counsel for the victims. And I will not tolerate violations of that. Likewise, I know that much of the evidence in this case has been subject to orders sealing under that dissemination order or otherwise have been sealed by the court. I likewise expect everyone that has access to that information, whether it's sealed documents or information in sealed hearings or the information itself in the documents, to adhere to the confidentiality
I mean, they have been, to my
as it
knowledge.
relates to those. Okay, that's my one and only lecture for you for the remainder of this case. With that, let me hear
What do you guys think? Is he gonna be eating those words? I don't know. I mean, again, they've been really well behaved. I don't know that but it'll be interesting to see, right? Because typically in most trials, there's several lectures along the way once they get going, right, in trial. So we'll see.
from you. We'll start with counsel for the state.
Your Honor, I don't know that we have specific questions we want to propose today. We're looking forward to hearing the scheduling. I think that's going to drive for us, particularly the distance involved, any questions that we may have. I appreciate what you've already mentioned to us, and we will certainly honor all of that. Thank you, sir.
Taylor?
All
Thank
right.
you, Your Honor. There are a few issues that I wanted to make the court aware of as the
issues.
court decides on the scheduling order. We want the court to know that our team has been working towards the June of 2025 trial date that had been issued by Judge in the case. But in candor to the court, I need to let the court know some issues that have come up that we face that causes me concern.
Okay.
First, I think the court's probably aware of the vast amount of discovery that's been exchanged in the case by reviewing the record. But since August, we have received about 398 gigabytes of new information. And I can tell the court that nobody on the team has read every bit of that yet.
How many?
So there's a vast amount of discovery to continue to go through. And
How many gigabytes?
we have received about 398 gigabytes of new information. And I can tell the court that nobody on the team has read every bit of that yet. So there's a vast amount of discovery to continue to go through. And I wanted the court to be aware of that. The second thing is that during the course of this case, we had an expert that we were working with, and that expert passed away. We have been able to refill that role, to have a new expert to do the work that that expert was hired to do, but we are not progressed to the point that I'd hoped to be through no fault of the new expert. The court should be aware of that as well. And last, as the court is very well aware, the system of delivering public defense is changing next week. As appointed counsel in the case, I do not have a contract yet. Nobody on my team is under contract for this case. I'm concerned about what that means, and I thought the court should be aware. Further, we have been able to access funding to help us prepare this case through Idaho Criminal Rule 12.2. At the current time, we're working with about 25 experts and investigators to prepare the case. I don't know if 12.2 will continue to be the way to get funding for those experts and investigators, or if that's changing. And I thought the court should know those things. Thank you.
Thank you.
Okay, so 3 issues.
So I am hopeful that Mr. Frederickson will ensure that the contract is available for you and your team next week.
Hold on,
I have no control over that, of course, other than to, as it relates to who I permit to withdraw from this case or not withdraw from this case. As to 12.2 funding, my understanding
Wow.
is, and I've had a discussion with Judge Munson, who has been serving, as I understand it, as
Interesting.
what we refer to as the money judge. I've asked him to remain in that
Hi, Angie,
capacity
baby.
at least through
So that's
the-
a big issue. That's crazy. So it sounds like with the public, so we know that Ann Taylor and her team was brought in from Kootenai County, right? So they're already from Kootenai County, not like, right? And so this is an issue, right? It sounds like potentially they could have people reassigned, but at the very least, there's going to be some issues potentially with the funding. And she was saying 25 experts. Wow, or experts and investigators, I think she said, but that's crazy. But the thing is that if there's not funding, right, for them, it doesn't mean that automatically they would provide different attorneys or whatever. Essentially, the defense team would have to withdraw. And I think let me back it up. I think he just said, let me see what he was saying, because I was typing. Hold on. Let's see. This might be the biggest issue of the three.
Experts and investigators, or if that's changing. And I thought the court should know those things. Thank you.
So essentially, let me just, before he says anything, remember they need funding for them as attorneys, but also the 25 investigators and experts, that costs a lot of money too, right?
Thank you.
Obviously.
So I am hopeful that Mr. Frederickson will ensure that the contract is available for you and your team next week. I have no control over that, of course, other than to, as it relates to who I permit to withdraw from this case or not withdraw from this case.
Wow. So is that sounds, wow. That sounds like he's saying that if there's not funding, he might not permit them to withdraw. As in they have to do it anyway, like without getting paid. That seems crazy to me, that this could be potentially what happens.
12.2 funding, my understanding is, and I've had a discussion with Judge Munson, who has been serving, as I understand it, as what we refer to as the money judge. I've asked him to remain in that capacity at least through the transition to the state public defense system in next week on October 1. My understanding is, and perhaps I will come to find out something different, but that once it goes to that system, 12.2, as it relates to public defense funded attorneys on contract seeking 12.2 funding, that's
Right.
no longer a thing, that would come through the state public defense budget, essentially.
And so that's what he just described as the situation that Ann Taylor and her team are in, where it's funding. So he's saying it would now come from the state public defender system. Angel Baby, so what's the other trial that you're watching? Curious.
I guess we'll find out if that becomes a problem
I
down
guess
the road, but that's my understanding, because that whole system that 12.2 is based upon is coming to an end. So,
Wow.
Given your statement about the trial date, my proposal to move this case forward into May is probably not going to land well with you, but that's what I wanted to talk about, is the timing of the trial.
The one thing I had thought about once I heard this venue was changed, once we knew the venue was being changed, I thought to myself that it might affect the trial date, because part of the big reason that they had been asking for the trial date they had was because of Lake County, right? Because of the university and the students being gone for the summer. And a lot of it was based on just the capacity, again, like having less people there, the capacity of the small community, the specific specific challenges, as it were. And so I actually had this thought. I was like, well, now that they're moving to a different venue, I wonder if, that date's going to stick, because now you're going to have a whole different set of circumstances, and the circumstances that were applicable for Latah be applicable here. So let's see what the judge, he was wanting to move it up. Let's see what happens.
I'm concerned with a trial as currently set for a number of reasons. But first, I want to find out from you, as you sit here today, what that trial looks like in terms of the number of weeks of trial, starting from after a jury is selected through the end of the evidence and before any potential sentence.
So we don't know yet. We don't know yet. What he's saying is that he was hoping to come today to this status conference and say, I want to move the trial up to May instead of June. But he was thinking that, and then now the defense has raised these three issues that potentially, I mean, if anything, I would imagine, we haven't heard it yet, but I would imagine Ann Taylor was going to want the date pushed out because of these issues. So he wants to move it up. Probably the defense was going to want it pushed out because of these new issues that just arose while they were getting transferred over, right, to this other venue, to the new judge. So we don't know yet. So this is what they're going to be discussing.
Phase. So
right now, he's asking them, this is important. He's asking them how long each side expects to take for their portion of their case in chief.
Estimates of that.
Your Honor, I think it would be a fair estimate based on what we know at this point to have a month and a half or perhaps a bit more just for the evidence for the guilt phase of the trial. I say that knowing.
Is that just your evidence or does that include defense evidence?
Well, I was just getting ready to say, I say that understanding or acknowledging that Ms. Taylor has estimated 2 to 3 months total. I do not know. We do not know what the defense has in mind for their case right now. So all I can speak to is what we anticipate for ourselves. But I would think the state's evidence in chief should be able to come in a month and a half or so.
Okay.
Your Honor, we estimate 4 weeks for the defense portion of the trial case.
Of the guilt phase?
Yes, Your Honor.
I'm typing, I'm going to put this on the screen.
10 weeks. In terms of if there is a penalty phase, should the defendant be convicted of one of the statutory qualifying offenses, how long do we estimate the penalty phase being?
Your Honor, from the state's perspective, I believe we're going to be relying heavily on the evidence that's introduced during the guilt phase and that the additional evidence that would be brought in, unless there's something we learned from the defense about their experts, it is probably would take no more than a week.
Taylor?
Your Honor, I would estimate 2 weeks for that part of any trial.
That's
For our evidence.
for your evidence.
Yes.
2 weeks. So that's 13 weeks total, not including voir dire for the jury. Right, 6, 10, 13, probably more like 14 weeks. I think he said a week and a half. Or hold on.
So my concern, because this trial is currently set to begin June 2nd and end approximately August 31st, is having it set to run the entire course of the summer. I think we will find it to be difficult on jurors in particular, jurors who may have children who are out of school.
There you
in
go.
terms of
So we're
being able to-
looking at if you were to round up approximately 14 weeks, if it goes to a penalty phase, right? Bifurcated trial. So 14 weeks, not including voir dire for the jury. Yeah, this will be a long trial. This will be a long trial. Yeah, I mean, I would say I've watched several trials. I guess a lot of the trials I feel like that I've seen have been probably like 6 weeks is pretty. I guess Karen Reed was 9 weeks. However, they took so many days off and had half days. But I feel like 6 weeks is pretty standard for a lot of these murder trials. So this is going to be double, more than double what we're probably used to. So
to spend time, go on vacations with them, et cetera. That's one concern. Second concern is with school that typically starts in mid to late August, and jurors or parents who may have kids going off to school, the timing of that through August. And that's my primary concern about that time frame. I had two proposals. One was to
It's different again.
start the trial in the evidence portion of the trial the first week of May. And the other would be to start the evidence in early September. And I'd like your thoughts on those. I'm not saying I'm have or necessarily will vacate the June trial date, but I want to look at alternatives here because I am concerned about that spread that takes the entirety of the summer.
And we hear you, Your Honor. By way of history, the summer, we advocated for that in Latah County because the courthouse is right across from the high school, and the summer would have the students gone. If we were looking at the other two choices, we would propose May.
Okay. Hi, Candace.
Thank you, Your Honor. Your Honor, I would have to advocate for September at this point, based on the 3 reasons that I gave the court before.
There's the 3 reasons on the screen for you guys.
So I'm not going to worry about the public defense change because I think that will take care of itself.
Okay.
The one thing that you brought up the most, I mean, I understand there's a lot of evidence, but May is not tomorrow. May is many months away.
So what he's saying, is that this is the opposite of the Karen Reed trial, where for any of us who watched it, as we know, in that trial,
there's no evidence of anything in this case.
Right now, here there's lots of evidence. So there you go.
Concerns me that you brought up as your expert.
Okay. He's most concerned about
not asking
number
you
2.
necessarily to give away any secrets prematurely that you may have in terms of defense strategy, but can you help me understand this expert if you're able to, and what their role is and what the prospects are?
Your Honor, it's really difficult to tell you much about the expert without giving away a lot. I can tell you that this is a very necessary expert for us to have on board. We've been able to find somebody to fill the role. I'm confident in the person that will fill the role. There just hasn't been enough time to get the work accomplished yet. I know that that doesn't tell the court a whole lot more than what I said before, but I really feel that that would disclose too much for me to say more. I could do so on an ex parte basis or with Judge Monson, our resource judge, but not in a public setting.
I understand. Do you anticipate being able to fulfill your obligations for your current expert disclosure deadline that was set by Judge?
I would imagine beyond, so what I could foresee happening here would be, well, they can meet the deadlines for their other experts for the expert disclosure deadline, but this one's going to have to be pushed out, I would imagine, because of the fact that they're having to find someone else. It's a cell phone expert. I don't remember that dude's name, but he did seem older. I hope it's not him though. He was awesome.
No, not with a lot of confidence. I think that the work is going to take longer than to meet that deadline. I think if we met that deadline, I would have additional information that I would want to be able to present. And maybe I would have been stopped from that with that deadline.
Okay.
So I don't have a motion to extend that date, obviously, and with the changes that occurred, I understand why you didn't file one out of the box, but the deadline I think is January 6th, something like that, if I'm not mistaken, for experts on the defense side.
That's one of our deadlines, Your Honor. Yes.
I guess the state have anything to say in response?
Not
One thing
knowing
I will
the
say
details.
is, what did she say for their case in chief? It was, I think I deleted that other banner. It was like 4 weeks for their case in chief. I have never seen a trial in my life where the defense's case in chief just during the guilt phase was 4 weeks. Oftentimes, if they have one, it's pretty minimal, or even like when they do have one, I don't know, a couple days, right? Like you had, I mean, I know there's been plenty of cases that we've covered that where there was, you know, an affirmative defense or you know, the defense did have a case in chief, but it was even a couple days, you know, was like, that was that's when they've got a good, you know, they've got an actual case in chief. 4 weeks, you guys, 4 weeks for their case in chief. That is, I'm trying to wrap my head around that, because, you know, normally what we see in defense, right, is they're going to be poking holes in the state's experts or their witnesses, you know, the investigation, things like that. And I'm sure they're going to do that, right? But their case in chief is going to be, you know, we don't know yet what the theory is, right? We don't know yet. Is it going to be, it seems kind of like the alibi thing, but again, that wasn't really, they didn't officially end up declaring that when they were supposed to, you know? And I think that was something that, I don't remember if that was ever fully ruled on, because the last thing I recall happening with that was that they were asking for more time, and then the state was like, don't give them more time. And I don't know that that was ever ruled on. And then other things started happening. So which is interesting. I wonder if that's just kind of someone like something that got forgotten about or what. But, you know, they hadn't officially said, yes, we have a solid alibi, right? They're kind of weaseling it a little bit because they were waiting on more information, I think is what that was, from the cell data and whatnot. Oh, and now I'm remembering too that they were saying that they needed more discovery from the state in order to, right, okay. So, but regardless, even if that's what it is, 4 weeks. 4 weeks. That means almost like, you know, I mean, they're not going to be burden shifting, mind you, but in a way, it's almost like they have something that they're going to actually try to not prove, but that's the only word I can think of, right? They're going to attempt to show something, right? Which is wild. So I wonder what it's going to be. Also, for anyone who wasn't aware, just while I've got it paused here, we've been covering the Casey Anthony trial, which we've just gotten started with. Our 4th episode of that will be tonight at 7 p.m. And what I've been doing for that one is I've also been doing like separate highlights videos for each episode. So for people who are wanting to jump in, you know, so far they're like around 5 minutes. I think the last one was around 11 minutes, but they're short. And it's just highlights of the testimony from the previous episode so that you can get up to speed, you know, and then, you know, if you don't have time or don't want to watch all the other episodes. So, so there is a playlist for that. So for each episode, you'll see there's a live stream, and then there's also a highlights episode video for each episode. But that episode number 4 will be tonight at 7. And I'm anticipating potentially the next episode might be tomorrow night if I can get it done in time. So, so hopefully if you guys want to join, we'll see you there. It's really interesting. And so far, everyone that I've asked this question to has said the same thing, which is that no one that we've talked about or asked in the chat, no one's actually watched the trial gavel to gavel. And that includes me. So we are watching it gavel to gavel for the first time. Everyone so far has been in the same boat of like, we just saw the headlines. We just know whatever the mainstream media, general consensus, right? And it is such a really interesting trial. It's spicy. It's full of surprises. It's really good. So and actually so far, when I looked on YouTube, no one has covered it gavel to gavel, like with any type of like commentary or whatever. So, which is shocking to me because it's such a famous trial, but no one's done it. So anyhow, I'm really happy to be doing this, and it's a good one. So yeah, all right, let's get back to this hearing.
Challenges Ms. Taylor and her team are facing, I don't really know how to respond further, Your Honor.
Okay. So he's not objecting to her request, essentially.
What do you think is a realistic deadline for you to be able to disclose your experts for everything? I'm assuming it was January, all save that one expert.
Right.
But with respect to the expert you had to
Right.
replace,
That's
when do you think
what
you
I was
could
saying. Just extend that one
disclose
expert deadline.
consistent with the scheduling order.
Other than the expert that had to be replaced, Your Honor, there were two separate deadlines. One was for trial experts and one was for mitigation experts. And I believe that I can make that deadline other than that one expert,
Can you tell me if the one expert is
That
a
makes sense.
mitigation or a trial expert?
a mitigation expert, Your Honor.
Okay. So it's not related to the cell phones. It's a mitigation expert. It's a mitigation expert. So in case you remember, they have to prepare for the event that if he gets convicted, they have to be ready to go straight into the penalty phase. And so the mitigation expert, it's a mitigation expert. That's what we know so far, is the one who passed away. Okay, see you tonight. Have fun with your errands. Be safe. I don't know where, I can't remember where you're at, but we're having hurricanes here where I live. So we're on like a tornado watch, flood watch, other watches. Uh-oh. And then we get the spinning wheel as soon as I bring up the weather, right? Let's go, YouTube. Let's go. Spinning wheel, oh, spinning wheel. I always try to sing some sort of spinning wheel song. This is so fun, right? We love the spinning wheel, but it's probably weather related. Although having said that, YouTube just does this, right? So don't know why I'm trying to make excuses for YouTube. Okay. Okay, here we go. Great.
And what do you think you need for that mitigation expert in terms of a deadline? Compared to that mitigation deadline was,
I believe it was March. I don't recall the exact date.
yeah, so that's a long time from now. So I have a lot of questions, but I'm hesitant to ask you the questions because I'm sure you're not in a position to answer them currently, given the forum. So, but March is a long time from now.
Runner, the time passes very rapidly, and I
I
appreciate
agree
the
with
court
her. It's
not
gonna-
asking questions I can't answer.
And the other thing, so there's two issues here in terms of the judge. Okay, the three issues that she's raised, they're on the screen. The judge is the most concerned about the issue number 2, the defense expert. So there's two different things that this could affect, right? So there's the issue of the expert disclosure deadlines. That's what they're talking about now. But then there's also the issue of, will they be ready for trial if he moves it up to May, as they've been discussing? So
I think if I had an end of April deadline for that one witness, I think we could make that deadline.
that does not give the state much time, though, right? That's if they go to trial in May. That doesn't give the state much time. Interesting. So they're probably gonna. He's gonna probably ask the state, would that give you guys enough time? If they disclose this expert at the end of April, would you be ready to go to trial in May? Well, maybe the next question. Holy crystal ball.
So understanding this is a mitigation expert, Thompson, how concerned are you about getting that disclosure closer to trial?
Yeah.
Closer to trial is somewhat relative. The end of April sounds like it would be on the eve of trial from the date the court is proposing. I think that would be, I'm not sure that would be realistic. And again, I'm not in a position to second guess
Sure.
what Ms. Taylor and her team are representing to the court. She had told us some time back that one of her experts had some health issues, and I think that she did tell us that that person had passed away and they were working on a replacement. If we're looking at a mitigation disclosure at the end of April, I don't know that we could be ready with all the final trial preparation for a May trial. I hate to say that. I feel like I'm cutting my own throat in a sense, but that's realistic.
Well, I can do one of two things. I can set a separate hearing ex parte to explore this further, but I frankly don't know how far that's going to get me. I mean, I can set a date, and my experience tells me that date will be complied with regardless, right? Yeah, 24 hours in a day, but if you use enough of those hours, enough days in a row, you get it done if you have to. At the same time, I don't want to put unrealistic deadlines. And so I can do that. I can have an ex parte hearing, or we can go ahead and reserve September. I will throw it to you, Mr. Thompson, is what you want, what you would advocate for.
Your Honor, could I have just a moment? Your Honor, we trust the court to do the ex parte hearing, see what's there and make the best decision and tell us what the expectations are.
Well, do you want to do that later today, or you want to do it tomorrow? You need more time? You want to come back next week?
Your Honor, I had planned to leave town today. I have other case-related obligations tomorrow. I could do it as soon as this hearing's over if the court has time, or I can come back next week at the court's convenience.
We might go ahead and, oh, cool. Where are you going, Blackwater?
I
That's
think we'll
fun.
probably be finished in here by 3 if we were to do it immediately after. Are you comfortable with that? Does that give you enough time to get to the airport?
She's
Yes, I believe it will.
leaving on a jet plane.
All right.
Doesn't
Well,
know
we'll-
when she'll
we'll-
be back again. It'll be
we'll
for
give that a
next
shot.
hearing.
Okay,
So that's Parte
right.
after this.
If, well, if I move this one way or the other, I will adjust the various deadlines that are in here.
Where are you going, Blackwater?
I won't adjust the next deadline that you have, understanding that you may be already committed to it, which I think is the motions related to the defense's motion regarding the death penalty, if I'm not mistaken. Is that the
Oh,
next set of
gotcha.
hearings that we have?
Yeah.
Those are now scheduled.
I believe that our briefs are due the 10th of next month.
In the Discord,
With
let us
the
know.
hearing later this fall and a reply brief deadline for the defense. And we are on track to meet those deadlines, Your Honor.
I'm sorry, you were saying, counsel?
Your Honor, I'm guessing the court has received our motions already. I believe we were set for November the 7th.
Oh, for the death penalty motion?
I
I'm
think
so
the
excited to hear that.
state's deadline for discovery has passed. Has the state complied with its discovery obligations, including those outlined in Judge's last order and other orders?
We have, Your Honor, and in fact, Ms. Jennings prepared a lengthy discovery that was filed with the Latah County Court when our discovery deadline hit. It is lengthy, but there's a lot of discovery.
Sure.
We recognize
How
that
much of the,
There's
did
evidence.
you say 300 gigabytes?
398. It's awesome.
198 since August 13th.
How much of that is new information?
Ms. Jennings could speak to that.
Ms. Jennings, can you speak to that?
Putting her on spot.
Your Honor, the defense was given, and I'm not sure if this is what they're referencing, but they were given a copy of the OneDrive from the FBI. Most of that was cumulative discovery that they had already received in another fashion. I'm sure there were portions of it that was new information. I've not
But
calculated
see,
how
they
much of
won't
that
know
was
until they
new.
go through it. So
So I can only rely on Ms. Taylor's, what she's represented to the court on that.
Well, I don't think she knows because it doesn't sound like she's looked at it yet.
Not all of it, Judge.
right, you have to go through it. So it doesn't matter either way. If it's
all
or
right.
not, you have to go through it. So time.
Well, I will talk when we're finished here with Ms. Taylor without the state present in a closed hearing. What else do we need to talk about today, or do you want to talk about today?
Nothing comes to mind right now, Judge. I know that there will be plenty of opportunity for other discussions. As far as your meeting with defense ex parte, do you want the state for any reason to stay around, or would you like us to get on the road back to Moscow?
Are you flying or driving?
Driving.
Okay, well, why don't you hang around just in case we need to, if I'm able to make a decision based on that, I can inform you what that is at least.
Yes, sir. Thank you.
Anything further, other than your your motions regarding the death penalty? Do you have any outstanding motions and the motion as it relates to Mr.
What about the
Kohberger's
alibi?
attire?
Because
Your Honor, there's no outstanding motions right now. I do anticipate filing several motions in the motion to compel deadline. As far as discovery goes, I anticipate there may be some follow-up motions. I, of course, will first try to speak with the prosecutor to.
I guess they're not going the alibi route then, because they would have had to disclose that.
Right. I think you will find I'm probably more inclined to hear things more quickly than you're perhaps accustomed to in this case. So just be aware of that. It'd probably be more along the usual, 14-day timeline with respect to motions. If there's a lot that needs to be done with respect to them, we can talk about that. But
That's wild because,
Okay.
I mean, that's wild because I feel like, everybody has said that in terms of how the timeline for in Latah, that everyone's been surprised at how quickly, I know that it feels like the trial's forever away, but in terms of how quickly, they would file a motion and then have a hearing. Everything that I've heard was like, wow, it's happening so quickly, and he's saying even more quickly. So that's wild. I mean, I don't know how he was able to make himself that available after being assigned, but maybe that's why he was assigned. Maybe he didn't have much going on. I don't know. I mean, because sometimes they would file something and have a hearing, he's saying within 14 days. I feel like that's kind of what it's already been, but anywho.
On that point, Your Honor, as you can see, they're a multifaceted team. And on motions, we try to assign them to specific attorneys. On various motions, would it be acceptable to the court for those attorneys who are not actively arguing the motions to be able to participate remotely? Or would you like us to be present? We're happy to do either.
I'm fine with that. I just prefer those that are going to be arguing to be here, just because it makes it easier to have that dialogue. So
Okay, thank you.
the others, if they want to appear remotely, that's fine.
Thank you.
And same for defense as well, depending on what defense wants to do. Okay. All right. Then if there's nothing else this morning or this afternoon, I guess we will be adjourned and have a discussion in a few minutes. All right.
Thank you, Your Honor.
Back in a few minutes once the courtroom is cleared.
All right.
All right. So here's what's happening. Oh my God. Okay. So, okay. Here's what's happening. So they're going to have their ex parte meeting, right? Just to discuss this defense expert who passed away and what the deal is and how long it's going to take. Remember, there's two implications of this. It's extending the expert disclosure deadline for this particular witness, and then also potentially how it's going to affect the trial date. So right before I went live, I did check the Idaho cases of interest page to see if there was any other court filings that had come out since this hearing, and there haven't been yet. Sometimes they might be filed, but they don't come up online until the next day or two. So I will keep checking. But basically, what we're waiting now, right? We're waiting. How is this going to affect the expert disclosure deadlines? But the biggest thing is the trial date, right? How is this going to, it seems clear it's not happening in June, but the question is going to be, is it going to happen in May? Is it going to happen in September? So we don't know yet. So we're going to have to be on the lookout. I will be on the lookout for, there will be an order from the judge with any changes to these scheduling orders, to the trial date, what have you, and all of that. So that's what we can be looking for. I will keep refreshing it. Again, for anyone who didn't hear me say this earlier, tonight we do have the next episode for the Casey Anthony trial series. Did the jury get it wrong? That's tonight at 7. So there's a playlist for that. But yeah, other than that, we will keep on top of things here. Thanks everyone for being here and for watching, for being a squirrel. Love you guys, and we will see you next time.